In the name of Allah, the Merciful, the Compassionate. First of all, please allow me to tell you that in the first session of the conference, I claim that, I have attended a number of conferences, especially those related to criminal justice, that was organized by the United Nations in Aswan, and one at the Italian Senate, and one in Vienna in Austria, and one in the United States. Yet, I firmly and strongly say that this conference, with this great elite, and with these respectful Egyptian dignitaries, I think this is a cornerstone, this is a step on the way, especially when this conference is being adopted and being rehabilitated by a number of human rights organizations. When I talk about human rights and I revised the Egyptian constitution after two great revolutions, I say that the second and third chapter of the Egyptian constitution, human rights, especially those related to social, economic, political, and cultural rights, it has been part and parcel of the Egyptian constitution, and I challenge that this constitution, as all related to human rights, has yet to be effectuated to the way that lives up to the expectations of the Egyptian people who have made these great two revolutions. As the newly elected parliament, which comes from the civil community, and I see the recommendations that will be concluded by the conference must be followed up in this, not only as human rights organizations, but by all the participants in the conference. And the conference, to all what was achieved, or that will be achieved by the recommendations. In my opinion, I see that the Egyptian citizens in the last 50 or 60 years have passed critical circumstances, have passed difficult, stormy economic, political, and social circumstances. Egypt has two wars, and the most difficult of which is the one against terrorism, and the victims of Egyptian people are very dear. In this conference, I would like also to express my gratitude to all the martyrs of Egypt since the Great Revolution. Those martyrs who have written their names with the letters of light and have sacrificed their lives. And those people are calling on us to enact new laws as to help them. We receive complaints as human rights committees about the martyrs, from the martyrs' families, that they have the rights taken away, they are deprived of the rights. We need to enact laws that would help the martyrs, especially that we have the sons and the families will find no source to earn their bread and their life. And the Egyptian citizen, in spite of the difficult economic circumstances, the country is doing their best to fulfill the requirements and the basic needs of the people. When I was in Vienna or in Italy, the Italian Senate, we have found that people want to cooperate with Egypt, yet this cooperation needs all our support. We need to dot the I's and cross the T's. We need to, we as parliamentarians, as civil community, we must know that a 200-year country that is being made 5 or 6 years ago, we have started to establish a new methodology for human rights. 6 years ago, in my opinion, believe me, there were no considerations for human rights before the last 6 years. Therefore, we are stepping on the way. There we need reconciliation, honesty. We need to be clear about our defects. We need to know that there are phenomena that need to disappear from the Egyptian society. But this will never happen unless we have confrontation, openness, and creating a new generation. In our Human Rights Committee, we have adopted two initiatives. The first is to teach human rights as a subject at schools from 5th year. My dear colleague Dr. Margaret Aither, Member of Parliament, and other colleagues are working on preparing the material and the syllabus for such subject. I think that the national education is important, but in my opinion, it is not alone important, but we need to teach human rights for the child, the rights and the duties of the child. When the child learns this from the beginning of his life, he will exactly know what his civil and political rights are without any fears. Therefore, we call on the children, know your social, economic, and cultural circumstances, because Egypt, after two revolutions, must change, and we must be the nucleus of change. We must be the driving wheel in change. And we tell the Egyptian people, there is no problem to say in the media, I disagree with something, and we should work on this based on the laws. Based on the laws related to the Constitution, or those complement the Constitution as enshrined to be binding for the legislative parliament. And I'm sorry for this. Now we will begin our session, and now Mr. Mahmoud Andil, the lawyer at the Court of Cassation, will talk about the constitutional penal issues. Mr. Mahmoud, you have the floor. Good morning. Thank you very much. This intervention is discussing the constitutions, the penal code related to the constitution. The first thing is the penal legislations, and I think we need to be the penal criminal. That is to include the penal, the code, and the procedural parts. Because when we talk about the criminal court, when we talk about the penal criminal code, we talk about the procedure and we talk about the topic. When we talk about the Egyptian constitution, especially the one of 2014, has given special attention to the chapter on freedoms and rights, public freedoms and rights, providing many guarantees for equitable and just litigation procedures and trials. We are talking about the Egyptian constitution system that would have a legislative system that guarantees the fair and equitable justice, whether at the Egyptian legislations or in Egypt's commitment to international conventions related thereto. It also guarantees the surveillance of the court on the work of the executive authority. Now, we talk about the relation, when the Constitution talks about the relation between judiciary and executive powers, we know that there is a classical rule of the separation of powers. This rule now has become the balance between powers, as when we talk about the material meaning of the word separation is somehow inaccurate, but the constitutional law is talking about the rule of balance rather than separation between authorities. When we talk about the procedural laws, when we talk about the legislative penal codes, all that is happening in Egypt, especially those related to terrorism that has struck many aspects in the rights of people, has killed many people. It has also hurt our dear brothers of Christian people. This has put the burden on the Egyptian people, especially the Egyptian parliament. These legislations are being prepared and drafted to face terrorism. In my opinion, part of the penal code is related to terrorism in particular, but in a wider sense it relates to the judiciary system and to the whole, the administration of justice in Egypt. I know that when many advisors are talking about justice, we know that the justice system is at stake in Egypt, whether through the slowdown of litigations or the complications or the what is the full conviction of the society that the regime is fair or not fair. I think the concept of justice in Egypt needs to be very verified and understood. Of course, there is a speech about the role of the state in combating terrorism. Therefore, we have to investigate that there is no voice higher than the one of terrorism. But I say no. The rule of law supersedes all other voices, even combating terrorism. Yes, we can combat terrorism through the law, through the rule of law, through the administration of justice, based on the principle of legitimacy. This is an important responsibility assigned to the state, because taking into consideration the rights and the freedoms of Egyptian citizens in a way that would not violate the rights of Egyptian citizens for an equitable and just tribunal and trials. We have some basic constitutional courts. We have the Supreme Court before the establishing of the Supreme Constitutional Court in 1976. We have the State Council Judiciary has asserted in many rules on the importance of rights and freedoms and principles governing equitable and just trial for the people, because we know we have to be based on the Court of Cassation, the Administrative Court, and the State Council Court. When we talk about terrorism, in the role of the state in facing terrorism, we say that terrorism is no longer a domestic issue, but rather a regional and international one. And it is of paramount importance for the international community, the United Nations, to give special attention to it, as there is a new post that is a rapporteur to protect the rights of human beings against terrorism. Therefore, terrorism has become part and parcel of not only the national but the regional and international agenda, and combating terrorism at the national and international level should be within the rule of law, the administration of justice, and keeping and protecting human rights and freedoms in general. When we talk about the Egyptian constitution, we say how to turn these constitutional rules in this great and advanced constitution of 2014 to materialize. And there is also another development, as based on the Egyptian constitutional rules, for the first time of Egyptian constitution of 1923, in the 2014 constitution, the word human rights has not been mentioned until 2014, as it was an untouchable sentence. It was a taboo at the time. But in the preamble of the Egyptian constitution, in the penultimate article of the preamble, as we will discuss later, in the Article 93 and Article 151 of the Egyptian Constitution of 2014, we talk about Egypt's fully commitment and obligation that is to ratifying a number of international conventions. Egypt has played a major part in international conventions, as Dr. Hafiz Abu Saada has explained, is how such recommendations in the UPR, in the Egyptian Parliament, will be put into effect, or the Committee of Human Rights or the Anti-Torture Committee in many recommendations and remarked on the reports, Egyptian reports, and there is no tangible evidence that we fully abide by our international obligations. The phrase in the penultimate paragraph of the preamble of the Constitution, which is read as follows: we write a constitution that opens the way of future and coordinates with the International Declaration of Human Rights in the way that we have accepted. As Egypt has not been, of course, part and parcel of drafting the Human Rights Council Charter between 1946 and 1948, yet the Egyptian experts were helping the Lebanese diplomat Charles Malik, who was participating in drafting the International Human Rights Charter, or the Declaration of Human Rights. And in Egyptian Constitution of 2014, Article number 93 states that as follows: the country shall abide by international conventions and charters of human rights that Egypt has ratified. This is new. It has never been it has never been prescribed as part and parcel of the Egyptian constitutions. In the last studies and academic studies in the courts, we have been talking about Article 151 only. But it's good to have the Article 93. I think that drafting such constitutional text may be appropriate. Yet, in the Tunisian constitution of 2014 was more developed in calling, and in Morocco as well, they have clearly talked about that international laws shall also apply to the internal affairs of the country. This is not, of course, included in the Egyptian constitution because it will lead to some controversies. But I think, as a start, Article 93 of 2014 is good, and Article 151 that has asserted the importance of the International Convention based on the domestic legal rule, that the President of the Republic shall sign the international conventions and it shall have the force of law. And the phrase "shall have the force of law" is related to a theory of the unity of law, because the international convention and the local law must be fully applied in a way that would make the citizens enjoy the rights and privileges guaranteed by law. When we talk about Egyptian international obligations, about legislations, criminal legislations based on procedural laws, we would like to say that Egypt has ratified the International Covenant of Political and Social Rights that was promulgated in the Egyptian Gazette, that was published in 15th of April 1982, and Article number 14 of the International Covenant is part and parcel of Egyptian law. But the main guarantee or the backbone of the equitable and just trial of the Egyptian citizens, this is based on the Egyptian institutions shall enforce the text of Article 14 of the International Covenant of Social and Economic Rights. When we talk about trial, when we talk about prosecution, we think about the accused and about the defendant before the court. We talk about the wider sense. We have 4 stages: is the arrest, the investigation, first of all the arrest, then investigation, then the trial itself, and finally the implementation. And then we go to then challenging the I think there is first the implementation, first of all the final judgment, and then the implementation of the laws, or the enforcement of such judiciary actions. Of course, to supervise the punishments, this is prescribed in the statute of the International Criminal Court in Rome 1998. Who is responsible for supervising Egyptian prisons, for example? I think the parliament should respond to the current standards that supervision shall be subject to the Ministry of Justice or to the police justice. This has been adopted in Morocco for some time. I think the supervision of the Ministry of Justice will lift the burden from the shoulders of the state and will solve many problems in a way that would provide more guarantees and standards to treat the prisoners in a good way, especially in a way that would enable good treatment for prisoners, in a way that would allow the Ministry of Justice to supervise prisons. We also assert Egypt's full commitment and abiding by the rules of equitable and fair trial. Also, Egypt's commitments within this declaration of the state of emergency in Egypt, as we have seen last month, that we have seen 2 churches in Tanta and Alexandria have been a subject of a terrorist explosion explosions in which 50 Egyptian citizens were killed. Most of them were Christians, and on the same day the state of emergency was declared for 3 months. This is, of course, legitimate to the states based on international laws and based on the International Covenant on protecting economic and social rights. But I fully assert that Egypt is committed to the Social Covenant Article 4, based that there are some rules that shall not be restricted. This is in Article 4 of the Social Covenant on human and political and social rights. If any state, according to the covenant, if any state has any emergency problems or catastrophes, it shall declare a state of emergency in a geographical area. Yes, this is restricted because there are some rights that shall not be restricted or shall not have exceptional, such as the right to life and the right of preserving the body and the right of equitable and fair trial. If the state has the right to declare a state of emergency for a specific period, I think what is understood from the narrow sense, it must be in the narrow sense, because as we know that in democratic states there are specific and very strict regulations and restrictions governing the application of emergency in a way that would not be against the rights and rights of human beings and the freedoms of human beings. Therefore, Egypt, when discussing law number 12 of 2017, the presidential decree of the state of emergency, especially it needs to work with article number 4 of the International Covenant governing social and political rights. I think this is very important when we discuss Egypt's commitment by the International Covenant, even after the state of emergency declaration. The next issue is related to the law of protestation. As we know, the law of protestation in Egypt has passed 4 stages. Stage 1, there were tendencies in the Egyptian society on launching the free association and the free assembly, has led to issuing law number 107 of 2013, in which people have the rights to hold peaceful demonstrations. There was a large controversy in Egyptian society about the rights of Egyptian people for peaceful assembly and peaceful associations. It was the demonstration. Actually, it was out of content. The law was actually inaccurate, and it was against the Constitution. Therefore, the Supreme Constitutional Court in December 3rd, 2016 has ruled. Sorry, here I'd like to say the Constitution Court has not considered it unconstitutional, but just article number 10 of law 107 of 2013. Also, the ruling of 3 December 2016 of the Egyptian Supreme Council, Constitutional Council, is to close the gap between the states. To solve the problem, has issued law number 14 of 2017, in which the society, people expected then that the country will reconsider the demonstration or the protestation law. Yet, unfortunately, only one article has been reconsidered as a response to the Constitutional Court, and we expected the state's response to be more positive, to reconsider the whole law of 2013 of the free association and the free assembly, peaceful assembly of the people. Therefore, when we deal, how do we deal with it? Is it restricted or is it a violation or what? We don't know. How shall we impose restrictions in the way that would enable citizens to enjoy the rights for free association and gathering? Also, demonstrations The second stage was the presidential amnesty, that presidential pardon. That was an attempt to dismantle or to resolve the problem in which maybe hundreds, I don't know exactly, who have been exposed to arbitrary detention and have been sentenced due to the demonstration law. Also, the president's amnesty committee came in a way to help people. The first list was 82 people, and the second list was 203. I think these two attempts, or the two presidential amnesty lists, it has now, I think, 285 people in total. I think this is not a big number compared to the number of those detainees. As my dear colleagues have expressed in the first and opening session, the impact of terrorism acts on death penalty. This is one of the major challenges facing Egyptian legislations, and we need to discuss it with a clear mindset. When we talk about death penalty, and as Dr. Hafiz and Mr. Ala has explained, the state needs to reconsider death penalty. There are many different views concerning death penalty or execution. Some people are for, some people are against, for some social, some religious, some community reasons. But in the philosophy of the modern world, the world is talking about cancelling or the abolition of the death penalty. This also addresses the countries who have yet to make decisions to abolish it. But what we are trying to do is to reduce or to fully and faithfully restrict the application of death penalty. And as we witness now with the expansion of the new wave of terrorist attacks against Egypt, there is an expansion by the state in using and applying the death penalty. I think there are two elements. The first is a judge who is burdened by 100 legislative articles that allow him to judge on death penalty. There is also a cultural heritage among judges to accept death penalty. This, of course, interprets the expansion in the death penalty application in the last few years. However, some articles or some judges, there were some sentences that were cancelled by the Court of Cassation due to some legal inviolabilities or some inaccuracy. When we talk about the expansion of death penalty, we talk about the expansion. We have to be clear. Are we with death penalty or against? Question number two, we should, if we are supporting it, how would we curb death penalty? How would we deal with the procedures governing death penalty? These, of course, takes us to another issue that is related to the Egyptian Constitution of 2014 in Article 240 related to the enforcing laws. I have my research. I have found that the Constitution of 2014, in spite of its importance, the legislator has left the burden of enacting 80 laws by the legislative parliament that it must take into consideration. I am calling on the parliament, please take 240, Article 240, in the word that in a way organized by law, that is 240. If we do not apply the law, it will be out of context. When we apply the law, we have 12 laws related to our meeting today, because we have 12 laws that need to be acted on the basis of criminal justice. The first one related to Article 96 and Article 240 governing the appeal of criminal verdicts. We are talking about the constitutional text for 3 years. The Constitution has been talking about 10 years in which the laws shall be amended. I mean the Articles 96 and 240. And also the procedural law shall be amended according to the Constitution in 10 years. I think this must be adopted in the Penal Criminal Code, and it will be followed by the distribution of constituencies, also the Court of Appeal in Cairo or the Court of Cassation in Cairo, whether there is the burden on the shoulders of the Ministry of Justice. Therefore, this of course has not taken place, and we have been surprised by the amendments related to the legal penal procedural law. I think some of them will seem to be unconstitutional, and I think they will be challenged before the Supreme Constitutional Court, especially those related to that it's possible to hear the witnesses. It was a must for the judge to listen to the witness. Now it has been left to the discretion of the judge to hear the witnesses. And I think this is part and parcel of any criminal rules. That is, there are many rules in which that in the absence of the accused, the decision shall not be done, but now it has changed. Now we also talk about Article 54, about the arbitrary detention. We must be very clear. There is a legal disappointment about the rules of detention, arbitrary detention, which is immorally and not human. It's not accepted by all means to leave somebody for 2 or 3 years under arbitrary detention and then he will be acquitted. To the best of my knowledge, I think this is not in any judiciary system. And things must be clear when we reconsider the rules of arbitrary detention, because I think we do not need legislative amendment. It was there in the rules, the precautionary rules in the laws before the revolution, which are not applicable. We do not need any legislative amendments, but legal amendments related to the compensation or the claims to be paid by the state due to arbitrary detention if the accused is acquitted. To leave for example, to put him under city arrest, for example, or not to allow him. We have many other alternatives rather than arbitrary detention. And the question for the public prosecution, why don't we use other precautionary measures than arbitrary detention? And we have the 2 members of parliament here, and we need to have the speed enforcement of constitutional Article 54, also in Article 99 of the Egyptian Constitution. It is yet to be done. It also allows the National Council for Human Rights to intervene in the civil courts. Article 99 of Egyptian Constitution of 2014, the current constitution, it entitles the Human Rights Council to interfere, to support the accused in any civil court. Also, Articles 54 and 55 of the Egyptian Constitution are sitting for the procedures, that is the legal assistant offices for those people with disability and the rights to receive justice. This is yet to be effectuated. It's also related to legal procedures. There is no law to protect witnesses or informers. This is one of the major catastrophes related to the corruption. We find this is related to the problems of public finance and public funds, especially the protection of witnesses against corrupt people. Also, in the Constitution, in Article 96, this is related to Egypt's abiding to join the Anti-Corruption Convention. One of the conditions is to protect the witnesses of the cases. There are huge pressures mounted on the witnesses, mounted on the informers too. And I think many people at the Egyptian administrative censorship regulatory system do not inform Why? Because they are afraid not to be protected. This, when taking these protect these people, informers, this will face corruption, and this will also help people to annex to the UN Anti-Corruption Convention. Article 98 talks about the rights of the defendants is related to the state to provide legal assistance for the accused or for the defendants. All this, if we have done our best to establish the law of transitional justice, we would have avoided such problems. In Article 241, the legislator is addressing the parliament to enact the law of transitional law. This is a big challenge for the parliament. I think the parliament, in my opinion, shall do their efforts to enact 13 out of 80 laws, and I thank you very much for listening.
تحدث حتى أراك. This is Imam Ali word. I have seen you today, and you have been acquitted and good speaker. Actually, in the beginning, I am taking the side of the civil society, not as a person working on human rights security or a president of human rights council, but also I am taking the side of the Egyptian lawyers, not only as an Egyptian lawyer, but also because both of them is a voice of the oppressed and people who have injustice that is unheard, and we need to convey their voice to the officials. Actually, after listening to Mr. Mahmoud, actually I have quick comment, and which is simple. Before Dr. Hafiz Abu Sa'da's speech, I am very happy that for the first time we have a common conference, and we greet him and congratulate him for the well-deserved PhD that he got. I want to tell my dear colleague, Mr. Mahmoud, regarding the Witness Protection Program. As a Human Rights Committee, we have traveled and we attended to the Interior Ministry in NIMSA, and we have a program to over the witness protection, especially in particular cases, not only the public fund, but also the terrorist and murder program. We need a witness protection program. Actually, all facilities from the foreign side were provided from the intelligence and the interior information. When we try to convey the idea, we have discovered that when NIMSA applied it, when Astoria applied it, and they dedicate 18% of the general budget to this program, because it take from 1 month to 5 years, and also it need no residency, and they changed his accommodation. They need a fixed pay, and they need a security in comparison to the number to the courts on the Egyptian courts, not only the public fund trials, but also the terror and the forceful robbery and drug. Maybe it will cost 25% of the Egyptian general budget to provide this program. Especially the witness in this case need a lot of resource and money to provide this right protection for them. Actually, I think this program is needed, but right now with the current Egyptian country policy and budget should be postponed. We can implement it in another phase. The current phase in which we are heading to discuss the general budget in 30th of June. I think the income will be limited, and it's true. It's not fair to our work, but it's our income. Actually, Mr. Mahmoud, supposedly he should take 15 minutes, and Dr. Mahfouz took 15 minutes, but unfairness, we give Mr. Hafiz is 23 minutes that Mr. Mahmoud took in his speech. We want to start an initiative for fairness and avoiding discrimination. Thanks the parliamentary. I may not take the whole 23 minutes. I don't want to get you bored, but actually I want to propose a very important point in the context of this workshop toward the penal legislation development under Constitution. I think I'm not talking about only about the penal law, but I'm talking also about the special penal laws, that which more severe and restricted than the general penal code. So reconsider the penal legislation should cover all the penal code, whether it's a general or special penal codes, to cope it and go it hand in hand with the international legislation and declaration and laws, like the laws for the fines. You have a £5 fine. I think there are a lot of similar things like that, which doesn't represent any deterrence. The other point, actually, we have signed international pact, so we committed to it, and we committed to amendments. There are no crimes that isn't covered in the Egyptian law, like the forcible disappearance. We have tried in Article 282 of the penal item, which covering arresting a citizen without a authority and authorization, but the fine is really nominal and symbolic. But after all, it's not the forcible crime, and the dealing with it is so insignificant. It's a crime against humanity, like the torture. So if one of this workshop reference and finding and recommendation, it may be a big project with the National Council or the Arabian Council. It's very, very important to work for 1 year to develop a the penal Egyptian legislation. Too, in this topic, I want to say the justice system in Egypt reputation have been harmed internationally. When we say about a decision from Egypt of a conviction, you can criticize it, you can say it's unfair, and the trial was unfair, and there were discrimination and bias. And I will say a very important word: all the conditions that should be provided for the political asylum is provided and qualified in this sentence. This is very important point. The world were choked with 1,200 sentence of capital execution in a circuit in one try or session. So if you want to take this effect away, it will take 10 years. And the people who traveled abroad, like the parliamentarians and met with the abroad delegation, it was a question 1,200, a capital sentence in one try or session. And so people asked about and challenged the fairness of the Egyptian justice fairness. So the justice system had a problem, and it can affect deeply the Egyptian relation with the world. After the Egyptian judiciary and its reputation and its sentence have a big and good reputation, now it's tarnished. There are a lot of examples. There are discussions in the United Nations regarding a trials in Egypt which have big comments and problems like the lack of the fair trial standards and the lack of the guarantees and conditions. And I will give you an example. In the investigation, the prolonged investigation is kind of torture. The investigation lasted for continuous 16 years. The challenges and obstacles facing the lawyer to get to the accused is failing the procedures, but you can't get to the general prosecutor, you can't get to a lot of the avenue of the trials like in Torah and the central security. You are not allowed to enter without a permission, but while the Constitution legislated that you can separate the lawyer from its client, but in Torah the sergeant can ban you from entry, even a soldier. So this point is taking on the Egyptian justice system, and it's challenge all the procedure. And if you want to exchange criminals, you can't. If you want to have a general prosecution, you can't do that. Doubting the Egyptian procedure is very is big, and it was resulted from that there were remarks, and these remarks were true. So developing the Egyptian justice system should be within the right of the Egyptian parliamentary and its human rights committee. We will help them. We have experts. These experts have at least 4 PhD holder in law and 10 specialized in human rights. And we have international organization can provide a lot of experts and a lot of expertise, and they have great experience in that. So we are deeply need the development of the Egyptian criminal system and the sentence and sanctions which implement the standards and the constitution of the fair trial and justice. I will give 2 examples for the penalties needing development. In the procedure side, the Egyptian take the direct suing or litigation, which if the citizen have been offended, he can resort to the court, and he commit the accused to attend the court in the torture crime. If the citizen got tortured, you can't activate a direct suit, and you should ask the general prosecutor, and it's under his discretion, while it's a right guaranteed and provided by the Constitution and by the international pacts and the declaration. So it should be a priority in the protection, and the state should provide accessibility to the judiciary, whether they inform the general prosecutor or not. The second point, the torture crime itself. What is its problem? Because a lot of you have talked about it. The torture crime. In Article 126, we have 2 items form the principle of the torture. item regarding the torture and the maltreatment and the humiliating treatment and the cruel treatment. There are 4 items in the torture crime definition, and they should be enlisted by 5 items. And we should differentiate in the penalty. Each crime should have its own penalty. If the torture led to murder, it will have as particular and specific penalty. If a slap cause a harm, it will have a specific penalty. If there is a prolonged investigation, it will have its specific penalty. But in our criminal law, there are 2 types of torture. If it leads to death, the sentence will be intensified. Article 29 talked about the maltreatment, and it ranges from 3 and 6 months. It also explained the light sentence of the torture. There are very important critical part of the law. In Article 126, they specify if the torture should be complete. They should have a confession or an information. But if the torture without aim to get information or confession, then Article 126, it will be maltreat. So the description of it have been changed completely, and it was our battle in Khalid Said case, because the description in Article 129 is opposing that. But when we talk about 126, we talk about the torture leading to murder, and the prisoner died during torture. What we are talking about now in the agreement have guarantees not only the sentence of the torture, also there are responsibility of the attendant or responsible of the place of the torture. You hold the people, you hold the person who is supervising the torture or who is responsible on the place to be held accountable. Then they will discuss with the police forces that they will have accountability. This is so. Fighting torture agreement doesn't cover only a specific kind of torture, but it also covers the auxiliary item to prevent that. Exemplary item to do that. The on-remand in prison and detention was one of the items used to facilitate the torture. When you want to torture, you want to prolong the period to the sentence and detention to hide the torture, trauma and bruises and remarks, to prevent the prisoner from suing us. So the prolonged imprisonment is a way to get away from the sentence and punishment. We are talking about legislative amendment which need to implement a constitutional right which is protecting human dignity. The human dignity was mentioned in the preface and in the Constitution, and also I want to say the human dignity will be provided if each one was arrested with and have been treated with respect and dignity. And also in the Egyptian public opinion, they say if some crimes, this person is disqualified from all the personal guarantees. The talk show start to cover it heavily, and they discussed to criticize the witness, and they criticize the idea of witness, but you are talking about the acquittal evidence which provide each one to provide its witness to acquit himself if he is an innocent. But on the other side, the general prosecution and the judiciary authority, they are fair, yes, but also they are the other party. So the general prosecution have the right to imprison the people and confiscate the people, but the prisoner or the accused doesn't have the right to provide witness, and his lawyer is separated from him. And finally, we want a fair trial. How? During the investigation, you are under the general prosecution and you want to get in and you are banned. One time, I got into a fight. It was 2 a.m. and I get to the general prosecutor office and I told him I am the lawyer of the prisoner. He said the prisoner doesn't want you. He said the prisoner doesn't want you. So I asked him, will you investigate him without a lawyer? He said yes. So I told him I just want to see him. When I get to the room to see the kid, he was laying down on the floor. He can't sleep. So I asked him, will you investigate with him like that? He said yes. So I think sometimes the procedure in the investigation criticize the whole judiciary system. So we want guarantee. We want to enlist all this guarantee on the law that the investigation will be invalid if the prisoner doesn't have lawyers. And they cover that. They have 3 lawyers on the general prosecution headquarters, and they are working for the general prosecution. So when I come to attend with the prisoners or the accused, they refuse that because they say they already have a lawyer. So if you want to provide the regulations in shallow without a real effect, it can't happen. That's why I want to tell you very important point. Mr. Mahmoud have pointed out to the appeal decision, and each lawyer know that most of the appeal decision regarding the fair trial in a criminal crime, like in the drugs or the guarantees or checking, searching, and the arrest, have nothing to do with political consideration. So 5 minutes of the permission and authorization from this general prosecution doesn't make the whole procedure invalid. Also, in the unfair and biased media say it's just formal procedures. I want to draw an example. When you say it's formal procedure, when the officer informed the general prosecutor that he have an suspected and he want authorization to arrest him, so the general prosecutor should grant him a authority as long as there is seriousness. The formal procedure is have rules and condition, but if we get rid of these rules, I will bring the fine and the crime form, and I will implant it for you, and I can fabricate the crime for you. So it's a guarantee for a fair and just trial, and we should do that. This is the balance. The authority have power and options, and we should empower the weak citizen to stop any unfair treatment from the authority. Egypt shouldn't lose the reputation of a fair trial, and litigation. And the investor can add the arbitration condition. So, and I can tell you a lot of the international decision against Egypt because the Egyptian courts and the judiciary system didn't deal with one and the later, all of them in publishing crimes, even in the publishing methods, including the shouting right, drawing on the walls, or crying loud. If you cry loud in the street, you can be arrested for a publishing crime. And also the legislative have forethought, he said, with any other means. So internet can be and the social media can be criminated also. So free expression became a granted and protected principle in any modern state. But I am shocked that there are still sentences in the publishing items and articles, and it also have been mentioned in many articles, and there are flexible context and formation like freedom of religion. We are criminalizing the freedom of the religion and the scorn of the religion. All the case, ask anyone, but the real scornful isn't criminalized. They said it's banned to handshake the Christian are atheist, and all these ideas, these bad ideas exist. But what the religious scorn is a criticize to the ideas and principle. So the freedom of religion is criminalizing. There are very important points about the philosophy of legislation and the intensifying of the sentence. Actually, when we do the Egyptian legislations, we did legislations in the Egyptian parliamentary. In the past, they formed a committee and they granted a budget, and they traveled abroad and they discussed it with the foreigners. Then they form the legislation. So you will find a French, German, and a lot of foreign ideas in our legislation. The question, why don't we do now to see what are the penal legislation abroad and what they reach in the general deterrence and try to copy from them, like the capital sentence. We perceive if we apply it, we will prevent the high crimes, but it doesn't do that. In my belief, the capital sentence is inefficient because the justice themselves, other than the exceptional 1,200 sentence, but actually the Egyptian judiciary have two rules. First, consensus and the sentence, then the mufti or the higher religious authorities to decide in this point. So the number of the decision issued in Egypt is so limited. And I want to add very important point. Egypt also stopped the capital execution in Mubarak regime a lot. When the revolution turned out, a lot of people who were in prison, who were sentenced with the capital sentence, were released, and most of them have a capital sentence. But finally, they got released. So what I meant, the sentence weren't implemented. Dr. Ahmad have a very, very important study in that if if we reconsider the high intense penalty and we try to scope them and decrease them. Second, if we want to stop or suspend the penalty, it doesn't mean that we transfer to life prison. Can we adopt this approach? By the way, Bouteflika haven't signed a capital sentence during his ruling. Jordan did that, but they accepted the pilot, unfortunately. But there are Islamic State took this strategy. Senegal stopped the penalty of the capital penalty. Some state in the United States, also in Japan. What I mean, there are systems and the states applying that. So I think if we studied these cases, we can stop the penal case, and we can study if it stopped or decreased the crimes, also the no crimes that I talked about. Do you think the capital sentence will deter the suicidal who bomb himself? Or should we give him a exit if he surrender himself, if he stopped the suicide operation? We want to. Now we are facing a no criminal phenomenon. So how the old legislation can do that? The revenge idea ended. The society revenge have been changed. Now there is no philosophy which is integrating the criminal or the accused or rehabilitate him and reintegrate him in the society. The revenge is past.
Sophia. And other articles are important. When we discuss, for example, what I call a package of human rights in the Egyptian law, in the Egyptian Penal Criminal Code, we have to consider the incrimination of the internationalizing information, or I'm sorry to say, the incrimination of information. In the whole world, there is a classification of information: 25-year information, 15-year information. Sometimes it's no secret. I would like to tell you that one of the major sources of corruption in Egypt is scorning or degrading the importance of information. Sometimes they are sold by employees to the people outside Egypt. Some investors have received information that have been sold by somebody, which are very important geological information that would enable corruption. I need to have transparency in society. I need not punish people about sharing information. I am going to stop at this point, and I'm going to conclude with a very specific statement. In fact, in the whole world, we need to improve the record of human rights. To be frank, Egypt's record of human rights is full of many black points. I'm sorry to say that. Therefore, what we need to do is to use the means that would help improve the track or the record of Egypt in human rights. If I'm working on developing punitive and penal legislations to the way that would conform to the standards of international laws, this is a step. When I talk about the reconsidering of death penalty, this is the second step. I wish that this would be a transition. We send a message to the whole world that Egypt is serious about improving its record in human rights. Therefore, I would say we have a strong base, we have two solid feet. That is the Egyptian constitution, which provides Egypt with a privilege as a founded and strong base. The Egyptian legislature was aiming at establishing a state of the rule of law, respecting human rights, respecting inalienable dignity. Thank you very much for listening. In fact, Dr. Hafiz Abu Saada, before the PhD and after the PhD, are two different people with one strong, frank and honest personality. I have a comment before opening the room for discussion. I am going to talk about the International Convention
وقع عليها 88 دولة وصدق عليها 25 دولة ليس من بينهم مصر. الحقيقة ده مش هيتم التوقيع عليها إلا لما يبقى عندنا قوانين، والمقصود بالاختفاء القسري هنا طبعا هو الاحتجاز من قبل جهة رسمية.
That are people that are deprived. What we talk about compulsory hiding of the people and the forced hiding of people. We are investigating all these complaints, and as we are talking about these last 6 years, Egyptian citizen, in addition of not changing the rules of the constitution and the no change of the penal criminal code in the last 60 years, this had made Egyptian citizen to misuse or sometime will use the Egyptian law. I investigated 49 cases of forceful hiding of Egyptian people. 11 of them were right, and 38 were not right. Some people left the country, some people immigrated. Therefore, when we talk about this phenomenon, it is not very flagrant as people may expect, as we have 90% of the cases. When we talk about the law, and I say Dr. Hafiz Abu Saada didn't mention that the law, that the Egyptian judiciary is bad or anything, but Egyptian judiciary is very strong and very good. We have seen during the revolution how the judiciary supported the Egyptian state in a way that would elevate the Egyptian state. The courts, for example, that the hundreds of people who had sentences against them, especially those from the terrorist group. I saw the big number of people sentenced, but we see that sometimes they are retried in order not to give an impression to the West or to the other countries that we do not fully apply the law. Therefore, people are retried once again, and these sentences shall be null and void. When we talk about another point, that is accepting the other, that is groups who identify or who claim themselves to be Islamic politics groups, and in my opinion they are Islam is innocent of such people, and God said in the Holy Quran to the meaning of all people who have created you males and females, and in order to know and recognize each other. Also the Prophet Muhammad of Islam and all other prophets have adopted the methodology of tolerance for the best of humanity. Prophet Muhammad said in a hadith that nobody will be a Muslim until he loves for himself what he loves for others. And I mean others not only from the same religion, but others from other religion. The Prophet also said to the meaning of say salam or say peace for every person. This is the greeting of Islam. This is part and parcel of Islam. This is part and parcel of all other religions. But what we claim to be, that we claim that other peoples are disbelievers, I say that all all religions do not accept that. Dr. Hafiz has talked about revolutionary legislations in Egypt, and I fully support him that the vision is not clear in other countries, and we have our dear Italian deputy. I'd like to tell her that if some people believe that Egypt is a group of people with Bedouin or nomads dressings and the desert people, and they don't know how civilized we are and how we create a community dialogue. We have to improve the image in a two-way, to show positives and at the same time to deal with negatives and try to take measures to eradicate them as much as possible. And if there is a phenomenon to be studied, we need to study, as this image must be understood that it's not methodological. I think there is nothing methodological phenomena, something like forcible imprisonment or hiding or detention, arbitrary detentions or these things. I think there must be legislations to establish for a modern and civil state. We should stress the importance of a civil country. I'm going to give you 3 interventions. First of all, His Excellency Councillor Munsif Sulaiman, and I'm going to give him the floor to speak. Thank you, Mr. Chairman. Reform is a necessity. It's a noble goal, as development is a part of the universe. Yet, in order to make reform, we should know where we are. We should not exaggerate, we should not praise, we should not make any hyperbolic statements. The Constitution of 2014 is just a 3-year-old constitution. This great constitution, I would like to recall an article which is very important, that is Egyptian human is entitled to the right to dignity. This is a summary of the whole constitution. With this article alone, this provides the rights of all citizens for legitimate rights. This constitution has left or has assigned the Egyptian Parliament to continue to enact laws for the constitution, and the Parliament is a 1.5-year-old. This is a heavy burden on the Parliament. This is the first legislative Egypt that has been cleanly and fairly elected by the Egyptian people. It's the only legislative council in Egypt that is not controlled by a specific party. Most of the members are honorable people, and they are at the beginning of the parliamentary work. Yes, sometimes we blame them, sometimes we excessively blame them, sometimes we have burdens on them. But the topic of our workshop today is the Penal Criminal Code with 2 parts, the Penal Code and the Procedural Code. The Procedural Code is a long, it's an old-fashioned law with all its positives and negatives, and sometimes there is a mal-application, that is an incorrect application. The Ministry of Justice has held a meeting 2 months ago to change the procedures, which is proud of Egypt. It was represented all different generations of professors of law, lawyers, and also our distinguished councillors, previous and current one, and our distinguished lawyers. I think the Parliament will receive the new procedural criminal code, which will amend all the previous problems and will apply the Constitution. This will fully and faithfully eradicate sentences in absentia. It will also incriminate, and it will also put, the legal framework of the sentences whether in appeal. The alternatives of arbitrary detention have been taken into consideration, and I think His Excellency Dr. Hafiz Abu Saada has attended the conference and has seen how the law is effective. In my opinion, I am very optimistic of this newly procedure law. Now when we talk about the penal code, I reject it to be French, but it has been Egyptianized through application in the last 70 years. Dr. Hafiz, yes, isn't it? Yes, it has been nationalized. It has been Egyptian. I recall in history that one of the British chancellors in the 1927, in which he teased the Egyptians that they are applying Egyptian, the French law, because Mr. Saad Zaghloul, the Egyptian, has said, now it's no longer French, it's now Egyptian, it has been nationalized. Therefore, in the amendment of the penal code, I am certain to say that we have to take into consideration the newly theories of penal criminal codes. Death penalty in Egyptian law. Since the 30s of the 20th century, strict regulations have been set forth. I think more than any other law in the world. I'm sorry, I'm defending my country. I have never been a judge, and I have been advocating, and I decided not to go into the court. I'm just talking for history. I'm talking for right. The law imposes the constituency to be briefed on the verdict. It's not a majority verdict. It also imposes on the public prosecution to appeal before the Court of Cassation. And the Court of Cassation does not support the verdict unless unanimously. Then many strict guarantees on the application of death penalty. Please don't tease the Egyptian court to issue a 700-person death penalty in absentia. No, this is a warning. We are calling them to come to be tried, and this is a type of warning. Though I don't accept this verdict nor defend it, and this is, in my opinion, a stain or a shame on the forehead of Egyptian judiciary system. But thanks God, the Court of Cassation have overruled it. I've overturned it. When I talk about the law of prohibiting torture, the National Council have provided 3 draft laws by the treaty on which Egypt fully complied, and the Constitution have called for it. But who stood on the way of issuing this law? It's the Ministry of Justice. It's the Ministry of Justice. I do not blame them, but I just tell them that in the past they were strictly committed to the law they have. And I hope that the Parliament would be able to convince the Ministry of Justice that international conventions are important as part and parcel of the Egyptian legislation. As for history, when I was honored to submit the text of international treaties and conventions to the Ministry of Justice, they told me, would you like to legalize homosexuality? I told him, is this the only thing? And he told me, okay, get me the conventions and treaties. And all international human rights have sent me a copy of the treaties and conventions to which Egypt is a party, especially those of human rights, and we're going to provide it to the 50, and it was accepted.
we have a text that was also discussed by His Excellency, that is the right of the National Council for Human Rights, related to, which was also against by the Ministry of Justice. The Ministry of Justice has said no. It said that the State Council has said that there are some texts in the Constitution that need nothing included. This text, the National Council for Human Rights intervenes in many cases, in many misdemeanors, and sometimes the accused is acquitted. I think the case is not that bad. What we need is a reform, but never forget that we are combating terrorism, and no, nothing is more important than combating terrorism, which of course threatens the main right of man, that is the right to life safely and the right to worship. We have more than 70 people who were killed while praying, and I say, raise or abolish this penalty. How about, will I leave them free? Where is the justice? Where is justice here? When you talk about the mal-discretion, we need the Academy of Justice, and it needs to reform the second part of the justice, that is the lawyers. We have two wings for justice, the judges and the lawyers. Lawyers need to have a reform. We need to fully purify the number of lawyers for those people who are not working in a way that respects the ethics of the profession of lawyers. If you go to any police station or to any prosecution, even if you were Dr. Hafiz Abu Saada, you will find a gang to stop you from going there. A gang, I mean a gang of lawyers, because you say that we do not, we have to ask the syndicates to purify it, to take off from the syndicate those who are not working in accordance with the profession ethics. We have to call on the public prosecution and his vices to fully respect the law in word and in letter. Thank you very much for this intervention. I leave the speech for mothers.
آخر أو الجانب الآخر معالي النائبة إليزابيث.
And now we will listen to Mrs. Ambrotti. 2 minuti. سؤال واحد ومعلومة واحدة. السؤال، لو حصل بالنسبة للجدال في الدستور أو في الدستور الخاص ببلدكم، هل في أي تحدث عن نطاق العقوبة أو مناطق نطاق العقوبة؟ انتوا عارفين طبعا إنها ممكن تكون جنائي أو مدني أو غيره. احنا عايزين نعرف هل ممكن ايه نوع العقاب اللي بيحصل، هل ده موجود في الدستور، هل بالنسبة للرعاية مثلا او ايه نوع العقاب اللي بيفرض، هل ده مذكور في، احنا عندنا في الدستور الايطالي في نقطة مهمة خاصة بالعقاب، نوع العقاب نفسه، هل هو ممكن هل بيحدد مثلا العقوبة بتبقى تبع انهي قانون، اختصاص انهي قانون، مدني او جنائي او غيره، هل ده محدد في الدستور؟ النقطة الثانية هي معلومة مهمة اللي انا عايز اقولها. حضراتكم بتسمعوا في هذا النقاش وفي هذه الحلقة النقاشية ان احنا في ايطاليا عندنا طبعا راديو سياسي رئيسي. احنا بنبذل مجهود كبير ان احنا نحاول نترجم هذه المعلومات للغة الايطالية علشان الناس تقدر تستمع الى هذا الحوار، لان انا اعتقد ان في مواجهة كبيرة جدا على مستوى عالي لابد انها تكون معروفة للناس في ايطاليا بالنسبة للقوانين. بالنسبة طبعا محتاجين نترجم هذه المعلومات الى اللغة الايطالية عشان تبقى هذه المعلومات مفيدة بالنسبة للناس الايطاليين يعرفوا عن مصر بشكل افضل. Thank you. We'll take the questions and then we will answer.
Constitution. This is different from the application. I'd like to thank His Excellency because of the witness protection law. He find that this is not applicable, but in my opinion, this must be applicable.
We can't say that there are no administrative or economic
sanctions. The second point is when we are working in legislative issues, I'm against the punitive legislations. When we talk about the acquittance is an origin. It's not. It's a presumption. It's not a presumption. It's not an evidence. And the right of accusation is, of course, is more important. We cannot cancel the origin that man has been born in. The second point is, as I see, that there is a lack of legislative philosophy to enact legislations. Any legislation, there must be a philosophy behind it. The second is that this legislation will achieve solid goals for long times. I am calling that all amendments away from the 80 the laws to be prepared by the People's Assembly to be away just from the latest development is that we want to get the family of a dead criminal to leave their homes as punishment for what he did, the late person. This is a vision that is very, very short-sighted. I call on legislations that will treat with the case, but I have the fears that just legislations will have a long-term side effect, that it will deepen terrorism. I heard from the parliament that we need to punish the family of the terrorists. This will make it more difficult. This will exacerbate the situation. The other point is that we have a big problem in justice in Egypt. The main problem is not about the lawyers, it's not about those who stand before the police, in spite of the fact that we are fighting as lawyers, but the main problem that will violate justice is those members of the justice who are working for the executive authority, which is not a separation of powers. Thank you for this intervention. The last one. My name is Ahmed Naguib. Visually impaired, visually challenged. I have two questions for Mr. Mahmoud Andil. What are the guarantees and the regulations of the procedural law for people with special needs, and are there any articles that protect the right of those with special needs in this law or the amendments thereto? The second point is, I'd like to thank Mr. Mahmoud, and there is a point about the people with special, the eligibility of people with special needs in Articles 12 and 13. That is the right to litigation, or the respect of people with special needs for litigation. The second thing is, I would like to tell you that I think the human rights subjects must be taught from the first primary, not primary 5 or primary 5 or grade 5. I think we have to tell the young people how to deal with people with special needs, especially in the integration. Please allow me to answer about teaching human rights as a subject. This we have made it in grade 5, not from ourselves, but this is the age of perception. That is for a child to know what human rights are. In the whole world, that, for example, the age of 11 or the age of 10, a child will be able to know what his rights are, what his duties are. But for your very important question, the guarantees for the procedures for people with special needs, this will be discussed in the next session, and it will be fully discussed and answered. Please, would you allow me to answer this in the next session? As for the question of Mr. Samir al-Bagouri about the guarantees of human rights is the actual application. Dr. Hafiz Abu Sa'da, please, will discuss this issue. I'm going to take the question of Her Excellency about whether there is a scope of the penalty in the Egyptian Constitution. I'm going to begin with this. Egyptian constitution has set forth something related to the legitimacy of the sanctions or the punishments. The first, the statute, the Egyptian constitution is based on this, but Egyptian Supreme Constitutional Court has specifically identified for the legislature that one, the drafting of incrimination articles shall be specific and accurate. Please, could you ask the Mr. Advisor to use the microphone? The Supreme Constitutional Court has identified or has defined the crime, how it's drafted in an accurate manner. But the Constitution has two bases. The first is the person of the punishment, that is, every punishment is personal. For example, I cannot punish the family of the accused of the criminal. This is a personal punishment, shall be personal. The second point, there is no crime, no punishment without a text. Nobody shall be punished unless there is a text by a legislation that this person shall be incriminated. The third point is the law shall not be applied unless from the date of its promulgation in the official gazette. Therefore, we cannot apply it retroactively, especially in the penal code. These are the principles that have been adopted by the Constitution and have been also ratified by the Supreme Constitution, who added accuracy and correct drafting. Fourth point, which I've not heard, is what is better for the accused. For example, if an accused is being punished for a specific law, and before the verdict, a better law has been, for example, enforced, for example, a law that commutes the sentence, in that case, the accused will benefit from the new law. The Constitution of 1923, could you ask the Mr. Councillor to use the microphone? 1 minute? No. I have to conclude. I have to conclude and say in our session, and because we have exceeded time, and we have violated the rules, and I say that the Supreme Courts in Egypt are the guarantee. That is, Supreme Constitutional Court and the Court of Cassation are the guarantee for the people, as the defendant is innocent unless proved guilty. And this legal rule must be taken into consideration, because some media professionals try to make the accused criminal before even the verdict. Thank you very much for being with me today. The next session about the Constitution in the field of penal legislations. Mr. Magdi Helmi.